That's your story?
Welcome back to Advocacy, Alchemy with Professor Ross. Today we have a good one, guys. Today's case takes us to Solon, Ohio. We're going to April 20th this year, Easter. Police were investigating a serious hit and run involving a bicyclist. Within 48 hours, they tracked down the driver. His name is Benjamin Wells. His full case is in the comments. And confronted him right after at his own front door. The body cam footage shows him shifting his story, first saying he thought he hit a deer, then a pothole, and then admitting maybe it was an orange flash. Today, we're going to break this one down piece by piece, looking at the laws at play, the levels of evidence, and how a jury might view Benjamin's changing story. So with that, let's jump in.
That's it? Oh, yeah. Back door, Bob. Hello? Benjamin here.
Plan on doing, Bob? Hooking? Just hooking them up?
Let's see if he does everything. Hi. Happy Easter.
Happy Easter.
Okay, tell us a story.
So I was driving and something popped out in front of me. I thought I hit a deer.
Okay. That's your story?
Yeah.
I'm trying to decide whether to just give you a ticket or take it to jail.
Well, I wasn't entirely sure.
Okay.
I felt like I hit a pothole.
Okay.
It went da-dunk, da-dunk.
Oh. And then
I
blew your mirror off by hitting that chalk hole.
I took a look after I took a turn and noticed that the mirror was hanging.
Okay. You get your driver's license, insurance card. I'm going to call my boss to see if he wants you to go to jail or not with that story. I'd rather just to be honest. Just give you a ticket and go away, but obviously you don't want to do it the easy way.
Did I hit someone on a bike?
You tell me what you did.
I
know your wife's here. You might not want to see it in front of her or whatever else. We're just looking for it. It's Easter. 2 policemen show up at your door.
I wasn't
Obviously, you didn't hit a chalk hole.
I wasn't entirely sure because by the time I made the turn, that's when I noticed.
You noticed what?
That the mirror was hanging.
Okay.
My lane assist didn't go off or anything.
Okay.
I saw an orange flash on the side of the car.
Okay.
No, it came out of nowhere. It was like an orange flash. Okay. Like I feel like there was a side street and maybe something came out and was not entirely parallel to the road.
Were you coming from work or were you coming from a bar?
Work.
Work?
Yeah.
What time did you get off work?
About 3 o'clock, 3:30.
Okay. Where were you at after work? Where'd you go?
I went to a bar.
I'm just looking for you to be honest. Now that makes sense. Like, I went to the bar after work because I know a lot more than we're asking. I'm just looking for honesty. I know you're bullshit in the beginning. We can't charge you with OVI even if you were like, I was drinking or whatever else and all that, right? We're just trying to figure out what happened, get the people involved, get their information, get everything. That's what insurance is for, right?
Right.
But people make it more difficult. I'd rather not take you to jail on Easter.
I appreciate it.
Did you get hurt at all?
No.
Okay. Were you wearing a seatbelt at all?
Yes.
Okay. What part did you end up going to after work?
It was the Oaken Embers that's on, I work in
Which way did you go home? How'd you end up on that?
270 miles.
Is the car drivable still? Or?
Yes. This is the first one.
Did you hit a person or not? You keep asking me like a random thing or whatever else.
Well, my worry.
If you say I hit a person or I hit a dog or I hit a deer, like you told me you hit a deer maybe, then maybe you hit somebody on a bike. Like I'm only going to give you an answer to something that you tell me the truth on. I'm not going to give you the answers. You have the answers. I know a lot of the answers.
Okay, so was the person on the bike okay?
So you hit somebody on the bike?
I believe so.
Was it a female, a male?
I couldn't tell, but I was
Short, tall,
adult size.
adult, okay. Tall, short, fat, thin.
I would say taller side, thin,
Okay.
ish.
Okay. All right. So now you're telling the truth. They're in the hospital. They're in the hospital.
How bad is it?
My doctor. They're in the hospital. All right. I'm giving that because you're being honest with me now. That's it. It works both ways. I'm not just going to tell you a story. If you tell me the truth, I'll tell you the truth. All right. Somebody did get hurt. It's serious. All right. Stuff like that. If you charged anything with like OBI, you're looking at like felony 2 level type stuff. Like you could go to prison for a long time.
Vehicular assault.
The aggravated vehicle assault in a hit skip accident is what bumps everything up there. Like if you just hit somebody and did the OBI or did anything else, like it's down here. But when you leave and there's an injury, then it goes into vehicle assault. So basically, it's called that you assaulted somebody with this vehicle and left the scene. Right? If you stayed there, it wouldn't have been called that. But you left the scene and stuff like that. So that's what it's called. So we're not putting in the OBI part, right? So it brings it down. But he's like, it's still, because of the hit skip part, it's still going to be a felony. So you are going to get arrested. Right? It's just not going to be the higher level. So you can go ahead and turn around. Jail's got his back.
When can I be?
You want to give her your what?
Stand by a sec.
You want to give her your phone too? You want to take that with you?
I'll take it with me.
Okay.
Will he be able to use it, or?
Nope. But if he needs it for phone numbers,
You can use a phone. You can make phone calls. It's not from the cell phone. You could use our jail
he
phone.
could use the cell phone for.
So he could call
Right,
somebody.
send it to me.
So if he wants, if he needs.
How soon can I be released?
So we're going to go back, do the paperwork, and then they'll let you know on that.
What do you say about the car? If we,
He's still working on that part.
all right.
What do you?
So you just
Give
have
me
your-
whatever you have. Give me your phone. Well,
And then you could also call the jail too, put it through. Do you have any pocket knives or anything on you?
No.
Okay. What's this here? Oh, get that. Let's give her all that stuff, okay? That way it doesn't get lost in the jail and stuff like that. Now what do we got here? They won't let you in jail. Back this way.
All right, so we're in Ohio. So we're looking at the Ohio Revised Code. We have 2 laws. First, aggravated vehicular assault. This is found at section 2903.08. The law defines aggravated vehicular assault as it occurs when someone causes physical harm to another person while operating a vehicle. All right, now it becomes serious if and when it's tied to certain other circumstances like reckless driving, operating a vehicle while intoxicated, or fleeing the scene. Now here, all 3 of those could be active. We don't know. The penalty. Now it's a felony, typically a 3rd-degree felony, but it can escalate based on the nature of the injury and just the general circumstances. Now, a 3rd-degree felony in Ohio, all right, this is usually punished between 9 and 36 months in state prison. The fine can be up to $10,000. Also, there's some mandatory license suspension when you're talking about vehicular assault, all right? It can be between 2 years and 10 years if you're found guilty. Now here, something that's not seen in this video and they didn't talk about. He hit a 74-year-old bicyclist. Now, even though they didn't pursue this OVI, the reckless act and fleeing all make it squarely within felony third-degree territory, okay? All right, let's move on to the next one. And it's called failure to stop after an accident. Now, we heard the officer call it hit and skip or hit skip. It simply means leaving the scene of an accident. This is found at the Ohio Revised Code, section 4549.02. Now, it gives us a definition that drivers must immediately stop after all accidents. They have to provide information and, if necessary, render aid. Now, there's penalties if they don't do this, okay? Now, if there's a crash and there are serious physical injuries and physical harm, it's a felony third degree. Still that 9 to 36 months in prison, fine with the $10,000. Now, this is a class 2 license suspension. That means 3 years to life. It all depends on the circumstances. Remember, here, the officers are confronting Benjamin Wells at his home because he didn't stay at the scene of the accident. He hit somebody and then he left. That decision alone escalated his liability to a guaranteed felony. All right, next, let's move into the evidentiary standards because they're still at play in each type of case, whether it be a civil case, a criminal case, or just a traffic infraction. All right, let's move through these levels of evidence. There's 6 of them. We'll move from the lowest to the highest level. First, you have mere suspicion. Now, at this level, the government or the police, all they have is a gut feeling. No proof, no facts they can point to. The government can't take any action at this level. Now, what they will do is they'll go on high alert. They'll be watchful to see if there's going to be a violation that's going to be coming. Here, police had this when they saw the damaged Acura parked at Benjamin's house. Now, this is a couple days after a bicyclist had been struck. It was enough to spark interest, but not enough for action. Moving up a level, we have reasonable suspicion. Now, here, the police have specific facts and circumstances to believe that criminal activity is afoot. This level gives police a reason to investigate. Here, the officers match the mirror damage and just the overall car damage, matching the crash report. This was more than a hunch. Remember, the officer said he had seen traffic footage, spoken to the person in the hospital. There's been some investigation that's been performed before they came to his house. And the police were justified in knocking on his door and questioning him further about the incident. Moving up one more level, we have probable cause. At this level, the government or the police are going to arrest somebody. We saw that here. They had probable cause to arrest Benjamin Wells and charge him with vehicular assault and leaving the scene of an accident. At this level, probable cause, the government has concrete facts that would make a reasonable person believe a crime has occurred and that the suspect is involved. Remember, when you hear probable cause, that simply means an arrest is going to be legal. Moving up one more level, we have preponderance of the evidence. Now, this one's important today. This level means more likely than not that the claim is true. This is important today because there's an injured person. This level's mostly used for civil cases when people are suing each other for money or when you're suing somebody to compensate you for any expense that you had to pay out of your own pocket due to their negligence. So, if the bicyclist were to sue Benjamin, all they have to prove is just 51% of the evidence in their favor that Benjamin caused their injuries. Here, it would be the physical match of the car and the injuries. They'll be notated with medical bills, a hospital stay that's been more than 2 days at least. Those scales, they'll tip fairly easily in the favor of the injured person. All right, moving up one more level, we have clear and convincing evidence. Now, this level means that it's highly probable or substantially likely that the claim is true. This is higher than the last step we were on. At this level, the government or me and you, we're in a case where it's going to require more facts. This is going to also be important here because Benjamin, his license is going to be subject to this level of scrutiny. When he goes back to the Department of Motor Vehicles and they determine whether his license is going to be suspended for 2 years or forever, it all comes down to what evidence they're going to bring. At this level, they need about 75% of the evidence in their favor to win any action. So once again, you see this in several types of cases, okay? You're going to see it in administrative hearings, like DMV hearings about license revocations and license suspensions. You're also going to see it in child custody cases. You're going to see it in fraud cases. If we look at this example here, they're going to hear all those same excuses again, right? Oh, maybe it was a deer he hit, a pothole, an orange flash. All that, it really crumbled under the officer's questioning at the home of Benjamin. You couple that with the physical evidence, his admission that he believed he might have hit somebody, you reach this level fairly easy, right? 75% of the evidence in their favor, I think they have that. Moving up one more level, we're going to the highest level, beyond a reasonable doubt. This is the highest level in the American justice system. This level means there's no other logical conclusion besides the defendant being guilty of the charges that have been brought. A prosecutor would need to meet this standard for each element of the crimes. Now here we have body cams showing his inconsistent stories. You have a damaged vehicle. We have an eventual admission. I think a jury can conclude beyond a reasonable doubt that Benjamin struck the bicyclist and then he fled. And that's all important, even though that later those charges, they were dismissed, but he had to pay some money. The evidence path shows us how the prosecutors built this case up. Next, let's put ourselves on this jury. Now, let's step into the shoes of a juror. Imagine you're seated in the box and the evidence comes before you. Let's ask a few questions. Now, Benjamin tells 3 different stories before acknowledging that he might have hit a person. Now, as a juror, do you see this as confusion and panic, or is it deception? Now, I've told you the victim was 74 years old. He was left seriously injured and was still in the hospital 2 days later when the police came to Benjamin's home. Does Benjamin's decision to leave the scene weigh more heavily on you than the crash itself? Which one's more important? Now, jurors often ask, why didn't he just stay and call 911? Would a truly innocent driver mistake a full human impact for a pothole or deer? Now, this case had sort of a weird outcome, okay, because it was dismissed. He was assessed some court costs. He had to pay a couple $1,000s. So it's not really very clear. This happened in municipal court. And I'll say this, how many states work, all right? You have different levels of court, all right? Traffic offenses and violations usually happen in the lowest level in your state. That's going to be here in Ohio, the municipal level courts dealing with the different cities. Now, they have their felony level courts dealt with at the county level, all right? In order for a case to go over to the felony court, it starts in municipal, it's bound over and taken up to felony court. I checked in the felony level location, didn't find anything. I came down to the local level and I found him and his case, and I see this has been dismissed. So I'm not sure if it's going to be reopened for a felony or if they're completely done with it. Now, there probably is going to be a civil case opened against him from whomever was hit so he can pay their medical bills. But with all that, if you were on this jury and you saw what we have here, and you have the information that we have here of the victim, guilty or not guilty, based on the charges, hit and run, vehicular assault. An important thing to keep in mind always, jury duty is more than just listening to the story, okay? It's about weighing the credibility of everything you see, the evidence, what people say. It's about using your common sense also. A case like this, jurors gonna lean on their intuition, all right? Does the story really line up? It doesn't look good when the police come and right out the door. Stories, they're not true. All right, so with that, guilty or not? Okay, so what can we take away from this case? I think the biggest thing is choices can change our outcomes. Running over a bicyclist is tragic on its own, but the decision to drive away and leave the scene, that's what turned Benjamin's situation into a felony investigation. That single choice made everything worse. Next, excuses don't erase the evidence. From a deer to a pothole to an orange flash, each shifting story only weakened his credibility. What ultimately mattered was the mirror that's gone, an injured 74-year-old person in the hospital, and his eventual admission. And finally, there's some reality to the courtroom itself, okay? Benjamin was arrested. He was booked on a $50,000 bond, so he had to put up $5 to get out. And he carried a felony charge of vehicular assault for 3 months at least. Now, by July of this year, 2025, the case was dismissed. He had to pay costs of $673. Once again, also out of that $5,000 that he had to put up for his bond, they only returned $2,000 of it. So that other $3,000 was divided up and paid to some separate costs. We know $673 went to court costs. Looks like the other $2,300 went toward something else, probably restitution. And restitution simply means if there were some doctor bills, that goes directly toward paying what those doctor bills were. Now, even without a conviction, the arrest, detention, hearings, bond, all that, it kind of is punishment in itself, don't you think? Now, if you're in the accident, don't run. Call the police. Stay on the scene. Let the system do what it does. Walking away can turn a civil problem into a criminal record. Now, if you want to see Benjamin's official case summary, I have that. It's pinned in the comments. Drop your thoughts below. Did justice prevail here, or did Benjamin get lucky? Now, I think he's been put on probation. Somebody who's from Ohio, y'all look at these documents, y'all tell me, okay? Would you have convicted Benjamin if you were on this jury? Let's talk about it. Like, share, subscribe. Remember, this is Advocacy Alchemy, and I am Professor Ross. I'll see you tomorrow. Everyone be safe out there. If you're a bicyclist, be extra safe. Have a great day.
Subscribe to Advocacy Alchemy and come back tomorrow at 8:45 a.m.